Good evening. This is John Milburn for Laws 12063 Advanced Statutory Interpretation and Drafting. Thank you. We have one participant online, but tonight will be a relatively short session and essentially to camera. So those of you watching as a recorded session, please do try to join us on a Tuesday evening, 7 o'clock. I'd certainly appreciate the ability to interact because with this particular unit, it lends itself to interaction. So last week we were talking about the assessment regime. We were talking about some of the things that you might consider. By now, I trust that you've developed some ideas about the type of assessment work that you intend to present. So by now, you should have identified an area which, in your view, is unjust, inefficient, ambiguous, or otherwise in need of reform. And there are essentially two types of pieces of legislation that you could consider. One is to remedy, if you like, a mischief, or the second is to provide some form of benefit. So you can choose between those, and to some degree, one may relate to the other. So it may be that you're providing a benefit in order to resolve a mischief. So they're not mutually exclusive, in other words. But they're the two basic types. You can choose legislation from Queensland or Commonwealth jurisdiction and try to make it accessible, because you don't have a huge number of words to work with. You need to make it relatively simple conceptually. A whole range of ideas that you might come up with. In terms of coming up with an idea of what might be in need of reform, from a practical perspective, if you were to read the media, see what's topical, that might give you some hints as to how to introduce the area of law in which you're going to draft material. It may be that you've got a particular interest. If you can work something of your assessment into your work or your interests or your studies, so much the better. So try to value add and make this as practical and useful as you possibly can. So by the end of this week, you should have your ideas in mind. And please do go on Q&A on Moodle, collaborate, not collude, collaborate. Give us an idea of what you've got in mind. People can provide some feedback. I can provide some feedback and share some ideas. So let's see if we can get some interaction going on Moodle. In terms of resources, in this unit, I'll be introducing you, as I mentioned last week, to many websites. And it's going to take a little effort from your part to put all of this together in a workable manner. If you don't, there is a risk at the end of the unit, you'll feel as though you have a large quantity of material, but you're kind of lost in that material, lost in the process, and as it were, you don't have a clear path to follow in the context of drafting or interpreting legislation. So what I'm going to suggest is that you prepare something of a toolkit, and you may already have started that in statutory interpretation, depending on who took that unit when you did statutory interpretation. Certainly one of the things that I like to do when I take that unit, 11059, is to encourage people to have a toolkit. The second thing that you might want to do is a flow chart. Now, I know that in Michelle Sanson's text at the back, and also in the text itself, is a flow chart. You can use that. There are other flow charts. I'll introduce you to another one tonight, and they're useful ways of conceptualizing and following. So some people might rely more heavily on a toolkit, and by that I mean it's a repository for information and put together in a logical style, something that makes sense to you, that you can actually use in practice and certainly use for your assessment work. But I would like to think that in doing this advanced statutory interpretation and drafting subject, you're really motivated to prepare something in terms of a toolkit or flowchart or both that will help you in a practical sense, and not just something to get through this unit, so something beyond. Last week we talked about the different words that are used in the context of statutory interpretation and some of the phrases. So coming back to the idea of developing this toolkit for yourself, you would certainly need to have some clear definition of some of the key words. Last week we talked about intention, purpose, motive, so things of that nature, and you should progressively build on those sorts of things by introducing definitions, cases, pieces of legislation that support arguments around some of the key concepts. Now, from your previous studies in statutory interpretation, you'll recall that the purposive approach is very important, and it's the way that we essentially go about interpreting legislation these days. So the purposive approach interprets a statute where there may or may not be an oversight or an error. So you're entitled to look at the entire piece of legislation in trying to determine its purpose. And there are 3 points that I want you to consider when using the purposive approach. The first is to identify and then, if possible, explain the mischief with which Parliament was dealing. Now, given my earlier statement, the mischief could in fact be the provision of a benefit, so that you're trying to remedy the mischief might be that someone is not receiving an entitlement to which they should receive, and therefore they're receiving a benefit. So that's essentially the mischief. Number 2 is you need to demonstrate that Parliament has inadvertently overlooked an eventuality that must be dealt with if the purpose of the Act is to be achieved. And the third is to convince others with certainty that Parliament would have, or more likely than not would have, used the words that the Parliament would have used to overcome the omission if its attention had been drawn to it. So what I'm really getting at there is this, and it's relevant for the process of interpreting legislation or drafting legislation. The drafter has a limited number of words at their disposal. The intent of Parliament is for legislation to be drafted in plain English style. Have a look at, say, Section 15AB in that regard, Commonwealth. So there's an intention to limit the number of words to convey the meaning. But the problem is that when you come to deal with a factual circumstance, you need to be able to look at what it is that Parliament intended, demonstrate that Parliament actually inadvertently overlooked something that did eventuate, that couldn't fit within the limited number of words, and then argue that had Parliament specifically turned its mind to this scenario, it would have gone about introducing words that support your argument. So that's really the way that statutory interpretation arguments in a court will run. Now, where that's relevant for your first assessment is this. When you're drafting your material, you must try, if possible, to anticipate the likely scenarios that may occur from a practical perspective and think about how your legislation would be interpreted in those circumstances, and try to put up some hints or to actually deal with that potential or hypothetical scenario. From a drafting perspective, one thing you might consider when you're preparing your legislation, the first assessment, and it flows on into the second assessment, is using abbreviated titles. I'm sure you've all seen this, but you may not have really taken notice of the drafting technique. So if, for example, you're dealing with an organisation and it might be a long name, it's very common in law to abbreviate that for the sake of readability. So rather than mentioning this long name repeatedly, the idea is that you make up an abbreviation that makes some sense, usually an abbreviated derivative of the long name. And the way we do that is to put it in brackets and small inverted commas, or single inverted commas rather. So when you're drafting your material, you might wish to introduce that. Have a look at some pieces of legislation that have been drafted well, and you may see some of those ideas. And we'll talk more about some of the way in which you set out legislation in tonight's lecture. Now, if you're watching this as a recorded session, I'm going to invite you to view this lecture in a proactive sense. Now, what I mean by that is, I want you to be actively learning rather than simply listening to me. Listening to someone is useful, but actually working on something at the same time, I think, is even better. It's something I do. If, for example, I'm listening to a CPD seminar on, say, industrial manslaughter legislation, as the speaker is speaking, if I'm watching this as a webinar type situation or a recorded session, I'm going to the source material and following along. So if we're talking about a piece of legislation, I'm looking at the legislation, I'm looking at Note Up, I'm considering cases, I'm calling up the second reading speech, I'm looking at the other material, potentially bookmarking that, creating a document that relates to that area of practice, cutting, pasting, putting in tabs and hyperlinks, all of those sorts of things as much as possible during the live session. What it means is that I'm really actively working and working hard during that session to make the most of it. So please, try and do that while you're listening to me in this session. Let's start with the Statutory Instruments Act 1992, Queensland. So please call that up. I guess half of you will go to Legislation Queensland and half of you will go to AustLII, would be the general choices, but there are many other ways. There are other ways that you can access legislation. So the Statutory Instruments Act 1992. Now this is relevant if you're dealing with issues around delegated legislation. And also the Acts Interpretation Act applies equally to primary or delegated legislation. If you don't know the difference between primary legislation and delegated legislation, then you need to catalogue that, put it into your toolkit, have a definition that applies to that, try to provide a source for where these terms derive, perhaps have some examples of primary and delegated legislation. And when we talk about delegated legislation, and we'll talk about this more tonight, there are different types of delegated legislation. It's not just regulations. So by now you're looking at the Statutory Instruments Act 1992. Have a look at Schedule 1 and you'll see that it lists the provisions of the Interpretation Act that apply to statutory instruments. So I mentioned the Acts Interpretation Act applies, but certain provisions of that Act will apply to statutory instruments. So what is this Act all about? So the long title says that it's an act relating to the statutory instruments and for other purposes related to legislation. And the idea of the Act is to facilitate the interpretation of statutory instruments, improve their presentation, rationalise the way in which they're put through the system, for want of a better term, and basically ensure that they're of a high standard. So that's what the the Instruments Act is all about. And it applies to all statutory instruments. And I guess the question then is, what is an instrument? Well, that's the first part. An instrument is just a document. Simple as that. So we could have really called it the Statutory Documents Act, but instrument means any document. And the Act, the application of the Act, says Section 4, may be displaced wholly or partly by a contrary intention appearing in any instrument. So I'm suggesting that the Statutory Instruments Act applies widely to delegated legislation. An example of a magistrate's court case that attracted some attention, in fact it had 3 QCs, 2 other barristers and instructing solicitors, is Bell and Townsend. The citation is 2014 QMC, Queensland Magistrates Court number 30, and the argument in that case related to a certain complaint and whether it was valid or not valid because the complainant's appointment was inadequate and the appointment was a statutory instrument within the terms of the Act. So the takeaway from that is really this, that if you're looking at an event that has occurred and that event relies upon the delegated legislation to put it into place, so in this case, a complainant's appointment through delegated legislation, it's appropriate for lawyers to consider whether those things were done properly in accordance with the law, and if not, it may effectively invalidate the action that the person purported to take. In other words, if they're not duly and properly appointed under the delegated legislation, then they have no authority at law to do what they purported to do. So Bell and Townsend is the case there. So we said that an instrument is a document, but what's a statutory instrument? What's a statutory instrument? Have a look at section 7 of the Act. Subsection 1 says that it's an instrument if it satisfies subsections 2 and 3. And 2 says an instrument, which is a document, must be made under an Act or another statutory instrument, power conferred by an Act or statutory instrument, and also power conferred otherwise by law. So it's very broad. An example of paragraph C is an instrument made under express or implied statutory power and partly under royal prerogative. Subsection 3 also needs to be satisfied, and the instrument must be one of the following types. So here we have a list of delegated legislation or subordinate legislation: regulation, order in council, rule, local law, bylaw, ordinance, subordinate local law, statute, proclamation, notifications, guidelines, and other instruments. So a whole lot of things. So you can see that a statutory instrument is something which is made under an Act or another statutory instrument or some other power, and it's of a particular type, but they're very broad. So it's actually, when you think about it, the Statutory Instruments Act has very broad application and it's sometimes overlooked. So when you're drafting your legislation, you would need to at least consider the possible impact of the Statutory Instruments Act on the legislation that you draft. One of the keys to delegated legislation is the fact that power is conferred from one level to another. The Constitution doesn't expressly authorise the Commonwealth to delegate power. Have a look in Baxter against R. Way, 1909, 8 CLR 626, because that is authority for the proposition that Parliament does have that power. So even though it's not expressly in the Constitution, it is accepted and has been accepted for many years that Commonwealth does have power to delegate power to make laws. So even though we think about Parliament as being the law-making body, the idea behind delegated legislation in many ways is that power is delegated through that process from Parliament to another body. At a Commonwealth level, have a look at the Legislation Act 2003, and that governs the process of making instruments. And these legislative instruments, documents, must be registered in the Federal Register of Legislation and laid out before the House of Parliament. And then they are subject to a thing called disallowance. So if you haven't heard of disallowance, have a look at this. You'll need to consider it for the context of your first assessment. So some of the terms that you need to become aware of are things like tabling and disallowance. Now, some are subject to affirmation by both houses, and some are not subject to tabling or disallowance. What I'm going to suggest that you look at, particularly at the Commonwealth level, is the ODGA's Australian Senate practice. I think I introduced this to you last week. I'm going to share the screen now, and if you're watching this as a recorded session, please do consider calling this up on your screen and following it. So hopefully now you can see ODGA's Australian Senate practice, 14th edition, and this is through the Parliament of Australia About Parliament web page. The particular chapter that's relevant to what we're discussing tonight is Chapter 15, Delegated Legislation, Scrutiny and Disallowance. Click on that and you'll see some excellent commentary in relation to the process. Do be aware of this while you're considering delegated legislation. And I mentioned earlier tonight flowcharts, and here we have an excellent flowchart in terms of the process of disallowance. And you'll see that on the screen there now. Figure 1, which deals with the scrutiny of delegated legislation. At the bottom, you'll see the reference to notice of motion for disallowance or withdrawal, and it's possible for that to occur through the Senate. So do try to look at that flowchart, work your way through that system, and get an idea of the process. So what you can probably glean from that is that the process of creating delegated legislation is very different to the enactment of a statute. There are no stages for the legislative passage for delegated legislation, but there is that scrutiny that I've mentioned there. And have a look at the Legislation Act, have a look at sections 8 and 15A, or 15 generally, and section 17. And in the Legislation Act, have a look at section 42 that deals with the issue of disallowance. When you're looking at the legislation, just a reminder, have a look at NOTA if you're using AustLII, and you'll see a range of decisions that exemplify the broad nature of what might be regarded as statutory instruments. So one that you might see there is a decision of Member Traves in QCAT. It's Goldfield Projects against QBCC. The citation is 2016 QCAT 362, and this was to do with a merits review. And as is always the case in merits reviews, certainly in QCAT, the member had to make what we describe as the correct and preferable decision. And in this instance, it was a review of decision of the QBCC to issue a direction to rectify work. So in that case, have a look at it. The tribunal found at paragraph 13, footnote 7, that the rectification of building work policy, which was described as the rectification policy, is a statutory instrument that must be applied by the tribunal in reaching its decision. And that is an area that's often overlooked in real terms. Okay, let's have a look at the slides for this week, the PowerPoints. I'll share the screen. We'll go to the PowerPoints. And the topic this week specifically is the structure of statutes and legislative instruments. So you can see that before I started this topic, I really had to cover what is meant by legislative instruments. So you now know where to look for legislative instruments at a Commonwealth level and a state level, and you've got some idea of what they mean. At the end of this topic, you should be able to distinguish between an exposure draft, a bill, and an act, explain the legislative process in detail, differentiate between principal, amending, and omnibus acts, identify the long and short titles of an act, explain the structure of an act in terms of chapters, parts, divisions, subdivisions, sections, subsections, paragraphs, and subparagraphs, and explain the commencement provisions of an act, and identify and utilise the intrinsic guides to interpretation found within the legislation. Do have a look at the way in which some of the words there have been capitalised and others have not. So this is part of the, if you like, the process of identifying how to properly write some of the words that we use, in this instance, in the context of legislation. At the end of the topic, we should also be able to explain the key forms of extrinsic information, including the explanatory memorandum, the second reading speech, reports of a law reform commission and reports of parliamentary committee, explain the relationship between principal and subordinate legislation, we've already touched on that tonight, and explain the process by which subordinate legislation is made, including the disallowance provision process. Have a look at ODGA's Figure 1 in the Senate Guide, and identify whether any elements of a statute have retrospective operation and what implications might follow. So what is the legislative process? Number one, there has to be some form of need. Now, this is where you're at with your first assessment. You need to identify the need for this new legislation that you're about to draft. And it then becomes a government priority for action. The policy department issues drafting instructions to the drafting agency, which is you in this instance. And number three, an exposure draft is released for public discussion. Well, we're kind of bypassing that step. But what you need to do is prepare a draft bill before the Cabinet and its committees, and the approved bill is scheduled for introduction into Parliament. The bill is then introduced, being read a first time, and the explanatory memorandum is tabled. So this is all part of your drafting for the first exercise. Then the Parliamentary Library may prepare an assessment of the bill, which we're not doing. Parliamentary Committee may hold hearings and prepare a report. Parliament debates the policy supporting the bill, but not its detail. And then Parliament considers the clauses of the bill in detail and may amend the bill. Then we come to the third reading, which includes any amendment. In the Commonwealth, the other house repeats the process from first reading onwards, and in the other house makes amendments. The bill returns to the first house for consideration. Both houses must agree to the bill in every last detail, and then it goes to the Executive Council, the Governor, who consents to the Act for it to be enacted. Of course, in Queensland, we all know that we don't have a Senate. Now, the types of Act, Principal Act, so key legislation setting out something new. Amending Act, changing that which is already in existence. Omnibus Act, changes detail of a range of acts already in existence. Consolidation Act brings the law into one place. There is no such thing as Shakespearean Act, but at least we've got a PowerPoint. Short title, everyday reference. Major Sports Facilities Act 2001. The long title provides generally more detail. Occasionally, in my experience, the short title actually describes better what it is that the Act is all about than the long title. But generally, the long title just expands on the process to give a better idea of what the reader should expect from this legislation. Now, we mentioned earlier the hierarchy, and here is a table or a graph, if you like, showing the hierarchy. So that's a good one to keep handy. And when you're looking at legislation, you want to get a feel for the different chapters and work your way down from there, so that you're getting this helicopter view, if you like, of legislation before you get right down to the individual sections, subsections, paragraphs. Commencement. Now, I think we all know this, that a law does not begin actually operating on the day it receives assent, not necessarily. It might be necessary to delay the commencement, and the Acts contain a commencement section, typically, which indicates when the Act is operating. Now, you can rely on the default provisions under the Acts Interpretation Act, Queensland and Commonwealth if you wish, but I think for the purpose of your exercise, it would be wise, I think, to include a commencement section. And in some very limited circumstances, the Act may have a commencement date before the Act was passed, but retrospective legislation is a very touchy area. Of course, we have both intrinsic guides to interpretation and extrinsic. From intrinsic, we have dictionary, definitions, object sections, avoidance of doubt provisions, and you'll see that those words used specifically quite often, notes, diagrams and flowcharts, and examples. Now, the reason I'm dwelling a bit on this slide is this is critically important for you in terms of your drafting exercise. You need to be aware of these different intrinsic guides, and you need to select which suit your purposes when it comes to drafting your legislation. Modern legislation uses all of these intrinsic guides to some degree at various times, not in every act, but they're widespread. Older legislation barely used this material at all. So you might have had a dictionary in the older legislation. You probably wouldn't have even had an object section. You may have had a preamble, but almost certainly you wouldn't have had notes or examples or diagrams or flowcharts. If you want an example of an excellent flowchart, have a look at the Commonwealth Evidence Act in terms of the admissibility of evidence. So when you're drafting your material, you've got to think whether you want to incorporate these things, and if so, to what extent. Then, of course, we have extrinsic guides to interpretation, the second reading speech, which you're going to be drafting, and the explanatory memorandum, and other materials such as bills, digests, parliamentary committee reports, and Law Reform Commission reports. Delegated legislation is made outside of Parliament, but may be disallowed by either House of Parliament. So that's a key point. Parliament delegates the power for others to make legislation in this delegated form, but Parliament has the right to disallow the legislation and go back to figure 1 in OGDAs, as we looked at earlier this evening, for the layout of how that occurs in practice. And of course, delegated legislation, mostly it's regulations, but don't forget those others such as rules, bylaws, determinations, ordinances, standards, etc. So by the end of this session, by the end of this week, you should know how a bill is initiated, considered, passed, assented to and commenced. You should understand the different functions of principal acts, amending acts, omnibus and consolidation. Understand the key components of an act, how it's set out, understand its skeleton if you like, the manner in which these things commence, including retrospectivity, and the intrinsic guides, as well as the extrinsic guides and the fundamentals of subordinate legislation. So all of those things you need to consider. Last week, there was a question, and it may have even been Nicole, asked the question about answers to questions in the study guide. If you haven't already noticed, I've included those answers in Moodle. All right, so a quick refresher in terms of how to go about interpreting legislation, which was specifically relevant in statutory interpretation and relevant in this unit because in drafting material, you need to be aware how others will interpret what you draft. So the modern approach, of course, is we consider context at the first instance, not later. A great authority for that, CIC Insurance against Bankstown Football Club, 1997, 187 CLR 384. If you undertook statutory interpretation with me, there's a fair chance that you did an assessment on CIC Bankstown. It's one of my favourite cases in statutory interpretation. It's one of the go-to cases. And you'll recall that in that instance, the Law Reform Commission report provided an answer to how to construe Section 58 of the legislation in question, which was the Insurance Contracts Act, because the Law Reform Commission report looked into the mischief that the statute intended to remedy, and the court was able to therefore determine whether or not a certain insurance policy had been cancelled prior to expiration date, and whether there was an ambiguity in that case. So why is CIC Insurance and Bankstown important in statutory interpretation? Well, number one, as I've mentioned, it meant that courts have regard to reports of law reform bodies to determine the mischief that the statute was intended to cure. Number two, it's a clear demonstration of the modern approach to statutory interpretation. That is, consider context at the start and not merely at a later stage if there's some perceived ambiguity. And number three, the courts consider the words and their literal meaning, but they do that in total context of the law and total context of the facts. So since CIC Insurance, courts regularly use extrinsic material to identify the purpose or object of a provision. Now, this is very widely used in practice. So if you're dealing with an argument about domestic violence or peaceable behaviour, residential tenant, whatever it might be, if you want to support a particular argument, one of the very best ways of doing that is to go to the extrinsic materials and extract material to support your interpretation, and therefore what you urge the court to consider within the context of that legislation. Now, on the topic of extrinsic materials, I do want you to have a look at Section 15AB of the Commonwealth Acts Interpretation Act. If you're watching this as a recorded session, please find that now. So Section 15AB is kind of a go-to provision because it deals specifically with the use of extrinsic materials in the interpretation of an act. And in short, it says that when you're interpreting an act, if material is not part of that act, but it could help you in ascertaining the meaning, consideration may be given to that material to do one or two things. Number one is to confirm the meaning as the ordinary meaning, or two, determine the meaning when the provision is ambiguous or obscure, or the ordinary meaning leads to a result that is manifestly absurd or unreasonable. If you're listening intently, you may be wondering, as I still do, whether the principles in CIC and Bankstown are a little contrary to that which is espoused in Section 15AB. Because if we look at CIC Insurance, we're entitled to look at the context from the outset. We don't have to have an ambiguity. But if we look at Section 15AB(1)(b), we're supposed to look at extrinsic materials to determine the meaning if the provision is ambiguous or obscure. So to me, there's a little hard to reconcile there, at least completely. Have a look at subsection 2, because it deals with how to deal with subsection 1 in those two parts that I've mentioned. So without limiting the generality of subsection 1, the sort of material that you can consider at a Commonwealth level, at least when trying to interpret legislation, are relevant reports of royal commissions or law reform commissions, committees of inquiry or similar bodies, reports of a committee of the Parliament, any treaty, any explanatory memorandum, any speech, particularly the second reading speech, any document declared to be relevant document for the purposes of the section, or material in journals of the Senate or the official record of debates in Parliament, Hansard, etc. So that's a list, if you like, of extrinsic materials that can be relied upon when seeking to interpret legislation. So I take from that a few things. The first is you must know how to access these extrinsic materials. So if, for example, you don't now know how to access a report of a committee of the Parliament of either the House of Reps or the Senate, then you must learn how to access that material, because that's a key piece of material for the interpretation of legislation. And if you're drafting legislation, you need to be aware of all of this because it may have a bearing on how you draft the material. So you can see the tie in there. All of this is things that you can incorporate into your toolkit. Now, in subsection 3 of that same Act says that in determining whether consideration should be given to material in accordance with subsection 1, regard shall be had to the desirability of persons being able to rely on the ordinary meaning conveyed by the text and the need to avoid prolonged legal or other proceedings without compensating advantage. In other words, sometimes it's all very well to go into a massive exploration of extrinsic materials and detailed legal arguments, but a court may reject that on the basis of it's not desirable to give something a meaning other than its ordinary meaning. So the default position really would be ordinary meaning applies, but you can be creative still in terms of the arguments that you use. Also look at section 14B, the use of extrinsic materials. So this is in the Queensland legislation. I mentioned the Statutory Instruments Act Queensland. 14B can be used in the concept of extrinsic materials. Have a look at section 15 of the Statutory Instruments Act. All right, so be aware of the effect of section 15AB and the equivalent provisions in Queensland. Also, have a look at Mills and Meeking. It's a High Court case, 1990, 169 CLR 214. And in that case, the High Court said if the language is clear and the purpose expressly stated in the Act, there may be no cause to refer to extrinsic materials. Now, you may be asking, well, why do I need to refer to extrinsic materials? The answer is many times you won't need to. It may be quite obvious. But if there is need to look at extrinsic materials, the simple answer as to why you should is that your opponent is likely to be looking at extrinsic materials, and the judge in a dispute matter is likely to be looking at extrinsic materials. So please do look at that. Also, you might consider a decision of K&S Lake City Freighters against Gordon and Gotch. It's referred to in your textbook. It's 1985-218 CLR 216, and we cannot simply read the words of a section of an Act and apply them without looking at the words of the surrounding sections, and indeed the Act as a whole. So K&S Lake City Freighters, Gordon and Gotch, is authority for that proposition. So this means that individual sections may be read slightly differently from their ordinary meaning, that is, a little more broadly or a little more narrowly than the mere words alone suggest. And if you remember that the leading case of Project Blue Sky against the ABA, 1998 194 CLR 355, you'll recall that some provisions may be leading provisions or dominant provisions, and others may be subordinate. So there's another qualification as to the way in which you might go about reading words in a section, because you have to consider the surrounding sections, and you have to also consider whether, in the case of what appears to be a conflict between the sections and the operation of those sections, which is dominant, which is subordinate. And some may be dominant, others may be subordinate. The authority for that, Project Blue Sky. When you're drafting your legislation, you'll more than likely have a long title. You'll certainly have a short title, and you'll more than likely have a long title. So traditionally, this is at the start. It identifies, if you like, the object or the purpose, and the short title is to give a snapshot and a quick way of referring to the legislation. Property Law Act 1974, for example. Now, short titles may be used in interpretation, but because they're so short, you probably can't use them to any great degree. But the short titles sometimes deal with the issue of intent, and the long title sometimes deal with the issue of purpose of legislation. And you remember that purpose focuses on the why and the who, and intent focuses on the what and the how. Another good case to have in your toolkit is Lacey against the Attorney General, 2001 242 CLR 573, which is where the plurality address the concepts of statutory purpose and legislative intent. So Lacey against the Attorney General is a good case there. And I'm sorry I'm moving so quickly, but we have a lot to cover. Now, preambles, we don't see them very often anymore. We still see them in international treaties and resolutions of the UN, but not so much in legislation. What we do see, what I expect that you'll draft into your material, is an objects clause. It's very common now, and it may be used in interpretation. And in fact, it's the first place that typically we look to if we're trying to determine something about a particular section. We're trying to mount an argument as to how that section might be interpreted. We look at the context, we look at the surrounding sections, but very soon, very quickly, we'll find our way to the objects provision to see how that matches in with what we think the section is all about. Definition sections, also very common. I expect that you'll more than likely have some sort of definition section in your draft mock legislation. And it's probably a good idea to have headings. If you can work that in, I know it's only a short piece of legislation, but if you can introduce some headings, that would be a nice touch. Maybe schedules as well. Notes would be useful also. And you can use examples. Now, have a look at section 15AD of the Commonwealth Acts Interpretation Act in the context of examples. And then, of course, there's the issue of the current meaning of legislation. And here's where it gets interesting, because on the one hand, you might be considering what Parliament meant at the time that the enactment was made, but the counter-argument is that an act is always speaking. So if you've still got your Sanson textbook at 147, Michelle Sanson says, the meaning given to words in a statute is the modern meaning, not the meaning of the words at the time the statute was enacted, unless, of course, the Act specifies otherwise or it's obvious from the context that it was intended so. So, in other words, the modern approach is that the Act is always speaking. Have a look at Coleman and Power, 2004, 220 CLR 1. Have a look at what Justice Kirby said. And so I'll just paraphrase what Justice Kirby said in Coleman and Power, and that is, the purposive test is objective. It's derived from the living language of the law as read today. It is not derived from the subjective intentions of parliamentarians held decades earlier, if such intentions could ever be accurately ascertained. So there are a few things that come to mind when you read that. You might think, well, why do we ever discuss the mischief rule? Why do we even consider what the intent of Parliament was in enacting the law? Is Justice Kirby telling us that all of that is wrong? Or is Justice Kirby telling us that the purposive test is different from the mischief rule when a lengthy delay between considering a matter and the original enactment of the law is present in that particular case? So I think really what Justice Kirby in Coleman and Power is saying is consistent with the modern approach and the purposive approach to statutory interpretation. You've been very patient tonight, and I will end now. Please do ask questions through Q&A. I'd love to have you join us for the Tuesday night sessions, and maybe we could engage in some discussions. In the meantime, make sure that you have your topic well in mind now so that you can start building upon it and thinking of ideas that you can incorporate into the material for the first and second assessments. Right, thank you for your time, and we'll see you next week. All the best. Bye then.